Just to set the stage, there used to be a lawyer in Charlotte, a really well-known trial lawyer a couple decades ago, and my dad, who was a judge for 30 years there, used to tell me about him. And one of the guy's major complaints was that the practice of law had gone to hell. And the reason, of course, was the Xerox machine. And what he said was that before, there was only one copy of a document, so you had very clear rules of authentication. You had not a lot of paper to work with. You could see the document. Somebody could authenticate it and say they signed it, and that's it. Now, his complaint back then, you had maybe 10 copies of that document. The practice had gotten impractical. So when I think about that, I wonder what he would think now, given that in most of my cases, there's at least 1 million documents to look through, and everyday lawyers are struggling to make that work. It does often, though, make me wonder what it was like to practice in a time where, and this is how I envisioned the practice back then, you get your case, your client comes in, you hear them out, you do some investigation, you decide what your strategy is going to be, and you sit down and you write a letter. And you take that letter and you put it in an envelope and you go put a stamp on it that you probably went to the post office to buy, and you drop it in the mail. And nothing happens in that case until your adversary gets your letter, opens it, talks to their client, makes the same kind of preparation, and writes you a letter back. Email has changed all that. And if you think about the progression, you have the Xerox machine, which changed this guy's world. And then you have electronic documents, people typing on their Commodore 64, you have multiple copies of that document. And then you have email, which dramatically increased both the pace and the number of communications that you have to find. And then you have texting, which is almost impossible to get because the rules of discovery were so slow to catch up to that technology and still are. And after texting now you have, and we'll go through some of these, I want to talk about some in specifics, but you have every day new apps that communicate in different ways, that have different properties, including security properties like encryption or deletion, automatic deletion. And so to frame the issue that I want to talk about, I'm going to talk about a much narrower piece of it, but to frame the issue, the struggle for litigation is having rules, or at least the application of rules, that can keep up with that fast pace of technology and communications. So that's a huge topic. I want to talk about one small aspect of it that comes up in most of my cases, which is employee business-related communications. The challenge there being to get your arms around proliferating means of communications with employees in a context where they're using different devices and different methods of communication. So electronic data, of course, has created huge problems for employers on a lot of fronts. It creates IP issues, it creates tons of technology or confidentiality issues, and for us, it creates a lot of discovery issues. And the struggle for the employers in all of those respects has been sort of, how do I facilitate my employees doing their jobs very effectively while at the same time maintaining some sort of control and access over those means of communication. So they handled this over history in a couple ways. First, the trend was what they called COPE, company-owned, personally enabled devices. So the company would buy you a phone, and you would have that phone, and that would be the phone that you were supposed to use for all of your business-related emails and texts or anything else. That worked fine from the employer's perspective. It was a little bit expensive, but they had automatic right to see anything on that phone, just like they have if the employer issues a laptop. The employees, however, as technology got more and more integrated into everyday life, didn't like it. They didn't like having two devices, and frankly, the employer-issued devices weren't as cool. They're not spending out money every year after year. As long as you can effectively communicate to get you the coolest iPhone or the sleekest case, And so employees pushed for bringing their own devices, and employers eventually had to adapt to that. And so now we have a bring your own device policy, which is the most common. And one of the things I'll talk about a little bit today is the need to make sure in discovery you understand what the company you're representing or the company you're litigating against has put into its bring your own device policy, because that'll control a lot of the parameters of discovery. And with respect to this issue of control and access by the employer. It's great for the employee. They can use their own phone. Great for the employer. They don't have to spend as much money on it. But it creates a lot of problems for us. And the reason for that is, whereas before you have everything going through a company's server because they maintain control of it, they have IT people who have a hand on all of the phones. And now you have potentially thousands of small silos of information. You don't necessarily know what's in them. You don't know what the employee is doing with them. You don't know, and you may not have a perfect right to access and figure all of that out. So that, in a nutshell, is the issue that comes up in a lot of my cases and the issue that I wanted to talk about today. And it's not just a litigation management issue. It comes up in a lot of regulated industries, many of which the regulators require the employers to maintain access to and monitor the communications of their employees. I mean, financial services, where I live most of the time, imagine telling FINRA that you can't provide them any information because your trader makes all of his employee or client communications through text message on his own device or using WhatsApp, which you have no access to. You'd have a big fine on your hands very, very quickly. And so companies have struggled with this, just like the litigation world is. And so for our purposes in litigation, the rules, like I said, have been a little bit slow, not a little bit, with respect to the pace of technology, they've been very slow to catch up. So the rule, the new-ish rule 26B2B, sets the baseline. And so we'll start, like most legal problems, with the rule itself. And 26B2B says that a party, the default for electronically stored information, a party need not provide discovery of electronically stored information from sources that the party identifies as not reasonably accessible because of undue burden or cost. So not much litigation yet on what identifies mean in that context and what happens if you don't identify particular sources of information. But the basis of the rule comes down to undue burden and cost and a few other concerns, and I have them listed here. And this is what I'm going to talk about today. So these discoverability factors that the case law has identified as sort of key for balancing the burdensomeness, the privacy, and the other issues. The first being, does the employer have possession, custody, and control of the personal device on which the information is stored? The next is the electronically stored information in question unique? Is it non-duplicative? And stated differently, could the requesting party find the same information through a different avenue, or do they already have it? Then there's a proportionality standard, which is pervasive throughout all of discovery now, and personal privacy concerns, which we'll talk about at the end. So possession, custody, and control is one of the more heavily litigated. I have a habit of getting ahead of my slides. The possession, custody, control is one of the more heavily litigated and sometimes one of the hardest to figure out, and one of the biggest challenges that is created by employees bringing their own devices and using them for company purposes. There are three approaches in the case law, the most common being the legal right standard, which basically just says if the responding party has a legal right to obtain electronically stored information, so if the employer has a legal right to get it from his employee, then the employer has possession, custody, or control of the electronic information. This is the approach that is favored by the Sedona Conference, which, if nobody knows, is the Bible of electronic data management and electronic legal issues with respect to electronic information. It's been adopted in the 3rd, the 5th, the 6th, the 7th, and the 9th circuits. And the one thing I want to say about this is for all of these, and in particular for that legal right piece, the key to that is figuring out what the company policy is with respect to its BYOD policy. So it's one of the first things that you should ask for in discovery when you're hashing all of these issues out. The other two standards are less used, the legal right plus notification, which basically means you have to turn over everything you have a legal right to, but also notify third parties who might have relevant information. And the last being the practical ability standard, which is a little bit amorphous and is a lot of times used in the context of subsidiaries. So just to highlight how bad that problem is or how difficult the problem is for some employees, and this comes up a lot in the trading world and the finance world where I am. You have a couple of new types of app, and I say new, some of them have been around for 3 or 4 or 5 years, but there's new ones coming out every day. So just to show a little bit of the progression, we have one type of app which includes WhatsApp and Signal and Telegram and Chat Secure, which is end-to-end encryption. And what that means is when I type in a communication through WhatsApp, for example, and I hit send, between the time it leaves my phone in the internet ether, which I don't understand, and the time it gets to the recipient's phone, it's just encrypted garbage, and nobody has been able to crack that code. When it gets to the recipient's phone, the WhatsApp app will unencrypt it and open it up. Obviously meant to protect the privacy of the message being sent. Another type being self-automated destruction messaging apps, a little bit more nefarious when used for business purposes at least. Where the Telegram Signal is the one that's been in the news a lot, particularly in the finance world, where there have been a number of sanctions for employees using Signal, where the device self-destructs after a certain period of time. You hear this most often in the context of Snapchat and other apps like that, which I hope my kids never use. But these obviously are read for a short period of time, and then they're gone. And so if you have a case about wire fraud or some other type of conspiracy, and you have employees that are using these apps, it's definitely a red flag. All right, uniqueness. So again, the court is very unlikely, and I'm not going to read the specific rules, but the court is unlikely to make you turn over documents if they're already on the server. And I just want to give a little bit of a spectrum for what documents are unique and which ones aren't. So on one end of the spectrum, which is the easiest, is like my phone. So every email I send for Moore & Van Allen goes through my work email. It's hosted on an Exchange server. They have access to all of that. So if Moore & Van Allen gets in litigation and they want my emails, it's very unlikely that the court is going to make me turn over my phone because they already have all that information. On the other end of the spectrum would be you take a deposition and the employee admits that, this never happens, but the employee admits that they're using Signal or one other type of app for business-related communications. Then you have unique because those aren't stored on the company server and you're likely to be able to get those things. In the middle, which is where a lot of litigation happens, and I suggest where a lot of the pushing should happen if you're trying to get emails from your adversary, is a case where the type of case lends itself to the use of these types of devices or offline communications. So for example, if you have an antitrust conspiracy case, and you find that there's some corroborating evidence of fraud, and you have employee 1 and employee 2, and from one employee from one company and another employee from another company, and you've asked them about their means of communication and looked at their phones, and they both have Signal on their phone. And nobody else in those companies use Signal at all. Red flag. But those are the types of cases where it is much more likely that because they're not going to be committing fraud or intentionally committing fraud typically on the company servers. So as a factor in terms of convincing the court that you need to get access to unique information, it's very, very helpful to consider the type of case involved and whether it lends itself to offline communications. So proportionality, I'm not going to spend a ton of time because this is sort of pervasive throughout most aspects of discovery nowadays. But what I did want to say is that the key, particularly in this context, the key to winning a proportionality fight is to do all the work ahead of time and not rely on your adversary to figure out what is burdensome and what is not. And when I say that, I mean, you need to send out very early discovery requests if you're not familiar with your adversary to figure out how they store information, how their employees communicate, what systems they use, and where that information might be. You need to take an early deposition, 30B6 deposition of their IT specialist or one or more of their IT specialists to confirm all that information. You need to do early work with your own e-discovery folks to come up with a plan and determine what information that your adversary has that will be difficult to get, and to strategize about ways to make it more efficient. Because if you don't, and you just send out a discovery request and say, hey, give me everything that's relevant, or come up with a plan given that you've told me what your systems are, their response is going to be exactly what my kid's response is when I ask them to clean their room or really do anything else. They'll say it's too hard. They'll say they have a stomach ache. They'll say they'll do it if you give them ice cream. And you might get something, but the key to winning the proportionality fight with them is to get so far ahead of them and to understand their systems and to come up with a plan where you can go in and not throw it all at the court and say, figure it out, but say, look, they say it's burdensome. We're suggesting you do X, Y, and Z. We've run this through our e-discovery folks, and we think we can accomplish it for this amount of money. The days are over where you can just rely on sending discovery requests and having the other side respond in a comprehensive way, often not because the other side is being obstructive, but because it's really hard to get your hands around all of this stuff. And the motivation really is on your side to find out from them. So finally, privacy, which is somewhat self-explanatory because everyone has private stuff on their phone. And with the limited amount of time left, I'll just leave you with this. If you want to think about how important this consideration is, consider that after tonight, almost everyone in this room will have pictures of us all doing karaoke on the stage. All of that could come out in discovery someday. This is an important concern. Thank you very much. Good luck.